the morning of Friday, the 14th of December 2018, and fortunately, right now I'm not in the heart of the city, although I will be back there later this afternoon, as I'll explain in a second. So I'm up here on Epsom Downs, and the sun is just starting to rise and reflect off Tolworth Tower as I look across West London here. It's a very fresh morning, about 0 degrees really, thick frost on the ground, but I gather up north there's a bit of snow, and I'll experience that as I'm heading back north this weekend. Well, what a week. This week is the 6th anniversary of the moratorium on fracking being lifted by David Cameron and George Osborne. And so 6 years down the road, there's absolutely no doubt in my mind that neither Osborne or Cameron had any thought whatsoever that 6 years down the road, basically this industry would still be nothing more than a figment of a very few mug punters' imagination. So what's happened this week? Well, Cuadrilla have returned to firing up the pumps, and guess what? On Wednesday they triggered a seismic event of 1.5, which one local resident said felt like a car had rammed the front door of the house. Well, obviously they have to stop for their statutory 18 hours, but look at what's happening here. Every time they fire up those pumps, they are effectively weakening the geology in the area around the Preston New Road, and every time, consequently, they fire up the pumps, then there is an increased risk of a very significant seismic event. Now, let's remember that it was a 1.5 magnitude seismic event, which eventually led to the moratorium being put in place in 2011. In fact, there were two significant events, one on April the 1st, which was a magnitude 2.3, which they got away with somehow. And then on May 27th, 2011, the 1.5, which of course is exactly what occurred on Wednesday. So there was a motion put before Lancashire County Council to effectively seek a further moratorium on fracking, which of course would have effectively been an ultimate ban, because the next moratorium that comes about, it ain't ever gonna get going for a number of reasons. But anyway, the ruling Tory party in the council, I believe it's a ruling Tory party at the moment anyway in Lancashire, and basically they amended it, and effectively it was a real woolly amendment, but basically what it does is gives Cuadrilla the opportunity to continue to try to persuade the Minister of State, and Claire Perry, of course, is the front person here, to raise the traffic light system from 0.5. And right now it has to be said that the unconventional gas industry is extremely grateful for all of the distraction of Brexit, because if it wasn't for Brexit, then obviously what's occurring at Preston New Road would be much closer to the front pages than it is right now. So meanwhile, that doesn't mean to say that they're going to get a free ride. They might not be getting the coverage in the media, but that doesn't really matter, because the vast majority of people who rely on their information from the mainstream media really aren't that important, because they're going to do whatever it is that the government tells them. So the important thing is that the activist community maintains its pressure on Claire Perry, on Greg Clark, on Natasha Engels, the puppet for the Oil and Gas Authority, and makes it very clear that the industry is going to still be under enormous scrutiny. And the pressure to pull out of Preston New Road is so great right now, and the stock price of AJ Lucas is going even further down the toilet as they attempt to persuade their investors that no, it's all under control and the British government's going to lift the limit. They just don't know it yet. Well, let me tell you, all the investors of AJ Lucas, that the anti-fracking community isn't going anywhere, and if that is lifted, then that may be the straw that breaks the camel's back and the Gilets jaunes take to the streets of England. And there's a building pressure. There is something not right, and an increasing number of people are starting to see that. And of course, over the last few days, I have been in the courts, the commercial courts in London at Fetter Lane, and I shall be back there this afternoon, hopefully to hear Judge Simon Barker give his ruling, having heard the submissions from IGAS, the barrister representing IGAS and Angus Energy, and two ladies who represented the interests of the residents who live in the Borkham and Brockham area where Angus Energy are seeking their injunction, and then my barrister Paul Powsland, who has been actively advocating for the injunction to be lifted at the IGAS sites of Ellesmere Port, Missing Springs and Tinker Lane. And it has to be said that of all the injunction hearings that I have either observed or participated in, the arguments put forward by my barrister were the most compelling yet. And he spelled it out in words of one syllable, that there is an increasing concern around the UK that the corporations are effectively buying a raft of legislation. And one of his observations on Wednesday was that this is legislation or quasi-legislation for the few, not for the many. He might have plagiarized that from somewhere else, I'm not sure where, but thanks, Jeremy. Anyway, the bottom line is that he has very, I think, ably made the point that if you have the money, then you can rock up at court and effectively put forward a case, and without any opposition, because you can ask for that initial hearing to be ex parte. And Simon Barker made it very, very clear that when an applicant for an injunction rocks up at the court, having asked for an ex parte hearing, it is not the role of the judge to represent the non-present opposition. It is simply for the judge to hear the evidence before him. So consider the implications of this. You have the money, you put together your legal team, you put in an application for an ex parte hearing, and basically the judge, unless he is happens to be aware of particular aspects of the law, which of course he may well be, but he is more likely to simply rubber stamp that application for the injunction. And then it's only afterwards, when the persons unknown have their opportunity. And of course the reality is that persons unknown don't really have their opportunity, because although they may come forward as interested parties, it doesn't necessarily carry a great deal of weight in the court. It is only when there is genuine opposition, either as a litigant in person or that opposition has legal representation. And this is, basically what is occurring here. And so consequently, my barrister spelt out for the judge that we're going down a very, very dangerous path here. And each time the unconventional gas industry seeks to push the boundaries further and further, it's just like one step forward, one step beyond that last injunction. And before you know it, basically, the industry that has applied for the injunction do what the hell it likes. So let me ask you to consider this perhaps not so hypothetical situation where an industry has the opportunity through permitted development to drill a hole, a deep hole, a very deep hole, not too far from where you live. That deep hole has been drilled on the basis that it is for the exploration of unconventional hydrocarbons. But then quietly the industry forgets about that original intent and then decides that it's going to use that hole to bury toxic nuclear waste. Now, because of the changes that were made to the Infrastructure Act in 2015, the company doesn't actually have to consult with anybody about this intent to bury this nuclear waste down this deep hole. So it just goes ahead and does it. And then the local community find this out, and of course they are in absolute uproar. They are completely dismayed that there's been no consultation about this, without realizing that actually over the past few years steps have been put in place by the British government to allow this to happen without any consultation. And then because there is massive opposition and the local community decide that they're going to stop the trucks from delivering this toxic nuclear waste to this site where they're going to dump it down this hole, all the company has to do is rock up to the court and seek an injunction, and they quote the precedent of all of the injunctions that have been achieved by the unconventional gas industry over the previous few years. And as Paul Powsland, my barrister, made it very clear to the judge, it does seem to be that Justice Morgan set a very, very low and far-reaching bar when he put the INEOS injunction in place, despite the fact that INEOS don't even have any planning permission, or certainly didn't at the time, they don't have any planning permission to establish well sites at the locations that they managed to get injunctions for. So it's extremely important that people pay attention to this, and frankly I am shocked that none of the supposed libertarian NGOs, with the exception of Friends of the Earth, who submitted a witness statement, but none of the other libertarian NGOs seem to even have this on their radar. And yet this is the greatest threat to what remains of parliamentary democracy in this country. This is literally driving a wedge, a judicial wedge, through parliamentary democracy. And Paul made the point that if this is what the companies want, if they want protests completely outlawed, so that the only protest that's permitted is to stand on a designated square and wave your banner and bang your tambourine, as Alan McLean for IGAS said a couple of days ago, then if that is the case, then effectively we no longer have a parliamentary democracy. What we have is a critarchy, rule by judges. And when Paul made this observation to Judge Barker, he simply shrugged his shoulders and smiled, as if to say, well, if that's what it takes, then so be it. This is a very, very important case, and I really and sincerely hope that, despite the fact he didn't appear to be taking too many notes through the case, and I hope that he wasn't thinking that he could simply rubber stamp Justice Morgan's injunction and with a few minor changes hand it over to IGAS and Angus Energy. And of course, if he does, then there will be an immediate appeal. I hope that Judge Barker is astute enough to realise that the decision that he makes, hopefully overnight and today, is absolutely seminal in terms of whether or not this country upholds any pretense of having a parliamentary democracy, or we only have a parliamentary democracy if Parliament puts laws in place that the corporations are happy with, and if they're not, they simply go to the commercial courts in the City of London, where commerce is king. Commerce has absolute precedence over the health and well-being of the wider population, and particularly those who happen to live in the desolate north. So pay attention. Assuming that Judge Barker does make his ruling today, which he has said that if he doesn't make it by 3 o'clock today, then it won't be until next year. But I'll be going back into central London in the hope that Judge Barker will be making his decision. And of course, if he makes a decision that is somewhat excessively favourable to iGas and to Angus Energy, then we will immediately inform Judge Barker of our intention to appeal. So if that's the case, then I will do a live stream with my barrister, Paul Powsland, outside the courts somewhere probably between 4 and 5 this afternoon. Now, after that, I shall be heading north, and tomorrow I shall be at the Misson Springs Protection Camp. There's a gathering there, an event there tomorrow afternoon. Everybody's welcome. It's a social event, and obviously I shall be giving an update on what's occurring with the injunctions, and taking a look at the prognosis for this industry. And the bottom line, I think, is that the unconventional gas industry in the UK ain't going anywhere, but it's not over yet. So it's really, really important that the opposition is maintained and sustained until either the government announces that it's done and dusted, or the industry itself realizes, or the investors realize, that basically it's a dead duck. So thanks for joining me today. Somehow I doubt that Cuadrilla will be firing up those pumps today. Obviously when they do, it's not too long now before they trigger something that is just of an order of magnitude that basically there can be no further debate, and it's time to pack up and go home. And bear in mind that where Cuadrilla are fracking hasn't been subjected to coal mining, but much of the other area, and particularly where INEOS and iGas are looking to drill their exploratory wells and potentially frack in North East Derbyshire, South Yorkshire and North Nottinghamshire, that area has been heavily mined for coal over the previous 2 centuries. And as Professor Mental Block, the professor from Keele University, who has produced a report stating that basically the risk of seismic activity by fracking under the previously mined areas is basically tantamount to just suicide for the industry. So Peter Stiles, I think it is, isn't it? Professor Peter Stiles, there you go. Came back to me eventually. Anyway, thanks for joining me today, and if you would like to support this campaign of humanity versus corporatocracy, then please go to either my website, ianrcrane.com, or to alternativeview.co.uk, and any donation that you wish to make is very gratefully received and goes straight back into this really important campaign that we return somehow to a full parliamentary democracy, as opposed to a facade of democracy controlled by the courts and the corporations. So thanks again, stay warm, and hopefully I'll be back with you this afternoon around about 4 o'clock. Take care now.